Now, you often hear at conferences that the next speaker requires no introduction, but actually it's true on this occasion because we all know who Elizabeth Denham is, and we're absolutely delighted and very grateful that you have joined us today. Originally, you were going to be speaking this morning, but you had to rush off to Parliament to give evidence on immersive and addictive technologies, and maybe later on there'll be an opportunity for us to hear a little bit about that. But just in case there's anybody in the room who does not know Elizabeth Denham's distinguished history, it includes having been the Information and Privacy Commissioner for British Columbia, and before that having been an Assistant Privacy Commissioner at the federal level in Canada. So I would say you were perfectly qualified to arrive here to do a job where nobody warned you that there would be a Brexit referendum as soon as you accepted the job. So that's an extra bonus bit of excitement for you. And we're not planning, by the way, to go down the Brexit rabbit holes. It'll be impossible to avoid it completely, but we'd really rather not make that the main focus today just because it's so speculative. But there may be one or two specific things. Now, what we want to do here is, rather than have a formal presentation, and as you will know, if you go to a lot of conferences, the more senior the speaker, the less substance you tend to get in the formal presentation because they, there you go, because they know, it's going to be reported and all the rest of it. So this is going to be a more informal, I think in the States they call it a fireside chat, but it's warm enough already without that. So we're going to talk about a few issues, a few topics that I think will be of general interest to everybody here. And then there will be an opportunity for you to ask questions. So let's dive in. Well, let's start at a high level, actually, the sort of 40,000 feet. So it's about a year since GDPR came into effect fully. And obviously, there was a lot of activity leading up to that, and your office did a great deal of preparation, as did many of the people in the room here. What I'd be interested to know is what's the main takeaways for you 1 year down the line?
So you started, I should say, first of all, thank you very much to Stuart and his team for being so flexible and moving my slot to the end of the day so that I could talk about e-gaming and immersive and addictive technologies, which is top of mind. So if anyone wants to ask me about that, then I am refreshed. You said from a 40,000 foot view, well, 40,000 is the number of complaints that we received under the GDPR in our first year. So, I mean, that's been uppermost in our minds, being able to do our bread and butter work, which is to respond to complaints and concerns from the public. So that's definitely top of mind. But if I think about the big takeaways, the first year under the GDPR and the lead up to the GDPR was all about what does the law say. Now I think we are going to be changing a track and focusing on what does the law mean. And that is a significant shift, I think, for data protection officers. It's a significant shift for regulators, and it's definitely a significant shift for council and for business. So the GDPR, I think, comes in with a lot of promise for consumers and for citizens, for change. But I think the question is are we going to see fundamental changes in business models? And that's certainly top of mind for me when I'm not thinking about 40,000 complaints. I'm thinking about how we can ensure that we have a real impact in the implementation of this law. So you will see that the ICO has started to tackle systematic issues, systemic issues, issues that affect perhaps an entire ecosystem, not just an individual company. And that's where I think we're going to be driving more change.
Interesting. So these kind of systemic or structural changes, I think we will find in our conversation come up in a number of different contexts. In fact, in preparing for this, I thought I'd better look at all the major stuff you've published in the last year. And this is just a sample, double-sided 2 per page of some of the reports. Not right up to date, because you just informed me on the way in that 2 hours ago you published another report, which I have to confess I haven't read, your response to the online harms consultation, and that is one of the topics I'd like to address. But if we cast our minds back to this time last year, a week after the annual conference, you published a report that actually was got a lot of press coverage and stirred up a significant debate, Democracy Disrupted. And then in November, you had your follow-up report to Parliament. There isn't time to go into all of the detail of that, but one of the things I found fascinating was you said in your November report that there was more to come and that you were working on further things. So can you bring us up to date on your thinking, really, over the last 12 months on Democracy Disrupted? And in the particular context of where we sit now, which nobody could have perhaps imagined a year ago, where in the next 6 months we might have a snap general election, we might have a third referendum. I don't know why the press talk about second referendum. The first one was 1975. Should the United Kingdom remain in the European communities? How many people voted? Do you know what the percentage was to stay in? 67% remain. And then, of course, you know the second one 3 years ago was went the other way, shall we say, 52% leave, and so could have a tiebreaker, best of three perhaps. It could even happen this year. So in that kind of rather unstable context we find ourselves in, can you tell us how far you think you've got in sorting out this problem with democracy?
I'll get right on that. So solving the problems of democracy. So in the context of data and data protection and digital campaigning, which we all know is here to stay, the challenge is going to be how do we upgrade and update our electoral laws so that they are 21st century laws? And what do we do in an environment where political campaigning and the harvesting of data happens 365 days a year and not within the designated time period that is covered by electoral laws? What do we do with foreign interference? What do we do with funding that comes from overseas? What do we do with the kind of data harvesting that's happening in the UK and elsewhere? So these are really challenging international issues. I think what our work has done is inspired the work of many others, including the G7, who are looking at these issues of electoral interference, foreign interference, cybersecurity around our elections. So there's major questions. But if I could just dial it back to, do I have any confidence in the data protection issues if we had a snap election, if we find ourselves in a referendum? Do I have confidence? Not in the law at the moment. So what we're working on and what we're going to be releasing this month is a code of practice for the use of data in political campaigns. So it's something that was really the central recommendation in our Democracy Disrupted report, that we needed a code of practice that applies to political parties, that applies to candidates, that applies to social media platforms, in what does good look like and what does compliance look like in data protection. So we've been trying to convince government and Parliament to put this code of practice on a statutory basis, like our children's code, like our media code, like our data sharing code. Why wouldn't a campaigning code be on the same footing, is my argument. And I'm going to keep fighting that good fight. But in the meantime, we will have at least guidance under our legislation so that we're leveling the playing field around the use of data, the use of third parties, the use of platforms to be able to target and communicate. So we have more to come. And the other thing I wanted to say is we have yet another investigation report that's going to come out in the fall as a final, not going to call it the greatest hits of Facebook and Cambridge Analytica, but a final report that is coming out of our forensic examination of Cambridge Analytica's servers. And if you were here this morning to hear my colleague James Dipple-Johnston speak, he will have explained to you how much data we've been crunching through to be able to get the answers of what was actually going on in that company, which we have now prosecuted and which is in administration.
Can you give us any kind of a, sort of Netflix-style trailer on Cambridge Analytica season 2 or season 3, whatever it is? I mean, what's going to be at the heart of this report?
I think there will be an answer as to what happened with the Facebook data that was harvested by Dr. Kogan and his companies.
Here in Cambridge?
Here, yeah. I think we'll have some answers around that, and also the extent of the provision of services in elections and campaigns around the world by that company, by Cambridge Analytica, and how they did their work. Because I think that's pulling back the curtain for the public and for journalists and for all of us that are in the weeds. And if we can't protect our democracy and if we can't maintain confidence in elections around the use of data, then I don't think we're doing our job properly. So it's going to remain an area of focus for me in the remaining years of my term.
Fascinating. So sort of moving on from that and picking up on your earlier comments about the ecosystems and whether more fundamental changes are needed to the way in which you and your office try to police the processing of personal data in this country in all kinds of contexts. Another complex ecosystem, which I think we need to talk about, is ad tech and real-time bidding, which, and your report from the 20th of June is highly recommended reading if you haven't read it yet, to everybody here. Now, there's lots of very technical stuff in here. It's extremely important because it's a very complicated ecosystem, and I think you've done a really good job in opening the discussion by explaining, albeit at perhaps a high level for some of the people here in the industry, but at a sufficiently detailed level, I'm sure, for many people, to get the beginnings of an understanding of what is processed by whom and for what purposes, and again, trying to start pulling back the curtain a bit. Now, I don't want to go into all the technical discussions about what happens if you can't rely on legitimate interest, and it turns out that consent is extremely difficult. Although I would just in passing say, don't underestimate the sort of reaction at the economic level to some of this stuff, because people seem to rather like not paying cash for their news and search and email and social media and everything else. And if the next phase of your work here really starts to disrupt that business model, which currently funds all of that, then I think that could turn out to be a much broader and very controversial step. And feel free to respond to that if you like. But one of the things that I think that is perhaps of interest to this audience, because it's a broader application, is the whole transparency challenge. So one of your conclusions in the update report was that the privacy information provided to individuals lacks clarity whilst also being overly complex. I'm not sure that tension can be resolved, because you point out as an example the IAB Europe's Transparency and Consent Framework, which lists more than 450 organizations that are behind the curtain, to use your terminology there, each with their own privacy policies, separate from the one on the site or service that the individual is currently using. So that's, you could argue, is a lack of clarity. But if you want to also reduce the complexity, how on earth do you expect people to achieve that level of transparency in practice and still have it accessible?
So this is one of the reasons why we needed to look at the ecosystem as a whole, to look at all of the players in that ecosystem, and to give the ad tech industry time to respond to the concerns. Because at the end of the day, our job is in law enforcement, and the law does require a sound legal basis. It requires, again, when you look at legitimate interest versus consent, where is the thinking gone into the reliance on legitimate interests? I mean, we're really scrutinizing that. So we have to enforce the law. The industry itself recognizes that there are issues and challenges that they need to address in order for them to be compliant. And we didn't just sit in an ivory tower and opine about the lack of transparency in the ad tech real-time bidding process. We brought together 100 individuals that were representing the industry, all parts of the industry, civil society, expert lawyers, so that we can have a conversation about where the challenges are with this industry. And we have given time for the industry to adjust to the law and to come up with their solutions. I think we need to be outcomes-based, and we can't tell the industry how to solve their problems. And I know it's a huge challenge. We are not working alone.
Yeah.
The challenge, we're not an economic regulator, but we need to take account of the impact of our decisions, and we need to take account of what we're doing in terms of putting pressure on business models. We get that. We're a member of the UK Regulators Network. We're working with the Competition Authority. We're working with the Financial Conduct Authority. So we're live to this, but we also have to enforce the law. So if somebody else has a better idea, I would be really pleased to hear that. But we also receive a lot of criticism for giving the industry time to sort themselves out. So I can't tell you how many letters and tweets and concerns that I have. If you know something's wrong, why haven't you taken enforcement action? So on the one hand, we know there's a need to fix the ecosystem around ad tech, and we chose real-time bidding. It's just one aspect of that entire ecosystem, yes. But it seems to me that there's a lot of sensitive special category data that is being shared without the knowledge consent of individuals. So how do we fix that?
Okay, so if I can push back a little bit on that, I think personally it's good that you are consulting and giving the industry time to come up with ideas. What happens, however, if after 6 months or however long it is, the industry, with all the incredibly talented people and resources that they have done a best effort in good faith to come up with a solution, and it turns out there's something fundamentally incompatible between the GDPR's requirements and the way this entire commercial ecosystem is structured, and that the general public don't actually want to start paying cash for their news and email and social media and everything else, then what would you do at that point if industry can't come up with a solution that's satisfactory to you from a purely data protection perspective? What's the next step?
Well, I think the next step would be, again, a broader industry approach here.
Right.
But I don't think that's going to happen. I think one of the things the GDPR has done, there's a lot of very innovative, talented, design-oriented companies and experts. And I think what the GDPR is doing is starting to put incentives in place and requirements in place for that innovation to happen with data protection and privacy by design at its center. So let's make that an imperative. Let's not make simply commercial success of companies be the KPIs for what is a quite mature design industry. So I think that's what we need to do. That's what the GDPR is meant to do. But if anyone else has a better idea, we can talk about it.
Well, we'll crowdsource that in a few minutes. But there's one other topic I want to mention before we get to that, possibly two actually. A lot of concern in society about how best to protect individuals, especially vulnerable groups like children, but individuals in society generally, and society as a whole from online harms. And of course, the government's put out its report on what it sees to be the problem and possible solutions to it. And so I'm interested to know what role you think the ICO could play, should play, in addressing this problem and participating in the debate. And do you think, for example, we need a new regulator? In which case, would you like to add that to your job description? Or who do you think should be the new regulator? Or do we not need a new regulator? Let's start with that.
Okay, well, just when we thought that we had everything covered across our landscape, so we had Brexit preparation in place, we had the GDPR work scoped anyway, we grew our office. Then the government decided to do a comprehensive think piece on content regulation for user-generated content. And they wrote this paper, which is probably the most comprehensive approach that we've seen across any jurisdiction on this issue, and lots of jurisdictions are looking at this. How do we actually balance freedom of expression and innovation with the harms that people are suffering online, the real harms? How do we get a grip on this? And we've seen these debates that are happening in Canada and Australia and New Zealand and France and Germany are all having these discussions. Then the UK goes and writes this comprehensive paper and says, we need a new regulator for this. And so we had to get our heads around this. We've issued as Chris said, we published our response to the online harms paper a few hours ago. Do we think we need a new regulator for user-generated content and content moderator? I don't think so. I think that would be crowding the space that we have with all these regulators that have some piece of the digital economy. I do think there's a gap in oversight where we do need somebody to be in this space.
Right.
I would prefer that it was an existing regulator such as Ofcom. I think there's some logic in that because they do media and content oversight and moderation now. I don't think it should be the ICO because I think the kind of work that this new regulator needs to do is going to be making decisions around personal messaging and private groups. And I think that's a tension for our fundamental role of data protection and privacy. Having said that, though, we have an active role to play in content moderation because the delivery of content is often based on personalization and profiling. So the use of personal data to actually deliver content is still in our space. So I think we will defend our perimeter, that we're there, but I don't think that we should be the new content regulator. And so I've explained that in a paper and explained some of the issues. The other thing is that right now, a lot of the drivers for content regulation come out of the Home Office. So it's very much about content that's already illegal and getting it offsite, getting it offline very quickly. And so that's a very Home Office-based set of concerns, and I don't think that's our space.
I totally agree with that last point, but my reading of the Online Harms White Paper, nearly 100 pages of it, is that the government has floated this idea. They want to go way beyond content that is already illegal, and they want to develop this concept of online harms in a very subjective way. So it's not about whether anyone's actually physically damaged or suffers financial loss or if they're injured or anything like that. It could even be at the level of somebody is misled by misinformation. It could be that somebody is deeply offended or hurt by some remarks that happen in an online environment. And I appreciate what you've just said about not wanting to be the content regulator, but do you have views about that kind of expansive approach to harm? Because, personally, when I finished reading this, I thought, well, if we do need a new regulator, it's probably going to be the Ministry of Truth or something like that. And I'm quite uncomfortable with that direction of travel and the impact on freedom of the press, freedom of expression. And if the test is going to be people are saying things that are not true and are deeply offensive, then I guess the first person to be gagged is probably Boris Johnson or something like that. But
I think, so my comment about the Home Office is that's a big driver for...
What, Boris Johnson?
No, not quite. The big driver is the Home Office and the concern about illegal content online and getting it down. So think of something like the Christchurch video.
Yeah.
So getting that content under control and how could that ever be live streamed anyway? I mean, it's appalling that AI can't actually prevent that from being posted in the first place. But
although I've been told, sorry to interrupt, but computer science have told me actually that was a very sophisticated content distribution arrangement and it's like a whack-a-mole exercise trying to shut it down all over the place. But
we can have that debate.
Over
That's
dinner.
good.
Over drink later.
Over drink, but no, in terms of the breadth of the potential for an online harms regulator to moderate information that may be offensive but isn't illegal, I think is going to create a really noisy conversation in this country. Yeah. And again, I think it's an important one to have. I think if you talk to people at the schoolhouse gates, they'll tell you that they're really concerned about their kids being cyberbullied. They'll tell you that they're really concerned about some of the shaming that happens online. They'll tell you that our defamation laws are not actually solving this problem.
Right.
So both, I think, across the political spectrum, there's concern about online harms. The question is, and again, with a new government, with a new focus, how broad is tackling this problem going to end up being? But user-generated content is so massive that a regulator in this space, I think, can only regulate the systems that, you know, companies are required to have takedown processes that are robust and work. If it comes to political advertising, they have to have something in place instead of ad hoc arrangements that come because there's been some kind of a crisis. So it's getting a handle on what happens online without compromising freedom of expression and innovation. That's why I said, we're not putting our hands up to be this regulator, but we're in this space because of profiling and personalization and the delivery of content.
Okay, that's very helpful. I mean, I'll stop in a minute. A related topic is specifically how do you increase protection for children? And doesn't that take you inevitably into the content space? So can you explain to us a little bit about how you see your code of conduct for protecting children being used in practice, and whether or not that actually will get you inevitably into the content space?
It's a great question. I'm not sure I'm glad that you asked that question, but here it goes.
I'm not sorry I asked.
Yeah. So the children's code, which is called the Age Appropriate Design Code, we're required to write this code under the Data Protection Act 2018. But what it does, I think it brings to life the kind of design requirements that any website, any game, any social media site that is likely to be accessed by children has to comply with design considerations. So this actually breathes life into privacy by design. What does privacy by design mean? This is an explanation of what does it mean when it comes to kids. And you know, I think I've said before, the kids aren't all right online. The internet was not designed for kids. If we had a do-over, if we had an opportunity to design the internet and internet services now, we would take into account the needs of children. Because we do in the offline world, we do in many scenarios. Why not for kids? So our 16 standards in our code, which is out for consultation right now, I think there's a lot of support in principle for them, lots of support. The status quo is not acceptable. Nobody wants to continue an adult version and nothing but an adult version for kids. But we also have a lot of pushback from industries, from the interactive entertainment industry. We've got pushback from news and media that we need to deal with. At the end of the day, though, I think we are creating design imperatives for what I said was a really mature industry that could put kids in the center of their design and think about the kids that are using these games and these e-games and social media sites and all of our interactive activities. So I'm really excited about the kids. I think the two most important pieces of work that we're doing at the ICO right now are around electoral interference, the use of data in campaigning, and protecting kids online.
Okay. Just one quick follow-up on kids. How do you think the problem of authentication and age verification can be solved in a way that doesn't increase some of the related risks in terms of privacy?
Right.
Because some people are going to have to collect a lot of extra data that they don't collect today, and that potentially is a further point of failure and a further privacy risk.
So I'm going to do some myth busting here, and our code does not call for age verification. And in my discussion with the select committee this morning, we were making it clear that we're not looking to age gate the internet. We're looking for design solutions. Perhaps for small businesses, it's going to end up being some certified age verification system. I know there's work to do in that industry, but I can see that at the end of the day. A lot of the larger providers already know they can estimate the age of the people that are on their site, and they can't tell me they don't know that.
Based on some of the profiling in your ad tech paper, you want them to
They
stop?
absolutely.
That you want them to stop doing?
I don't want them to stop doing it, but I think they know a lot about their users online that they don't need to have a verification system that collects a lot of primary identity documents to do that work. That's not what we're saying. If you look at the standards and take them as a whole, if you actually comply with most of the standards, you're not going to need an age verification. And if you look at again, we're a risk-based, proportionate regulator.
Yep.
And you have to look at the context of the risk that's happening to kids online. What we're really trying to do is we're trying to change the nature of how services are delivered with kids, because they keep eyeballs online, because they immerse them in this loop, this reward loop, and that's what we need to break.